Hello everyone. Good evening. Can you all hear me? Hello everyone. Good evening. Can you all hear me?
Good evening, sir.
All right. Please confirm my voice is very, very clear. Confirm you can hear me clearly.
Good evening, sir. Yes, we can hear you very clearly.
Yes, good
All
evening.
right. All right. Thank you very much for that. Good evening once again. Welcome to class. Right, for everyone joining in. Welcome to the JIIPCC Mentorship and Internship Program for the Medical Health Tech and Law course. We are currently in week one of our program. It's the start of a new session, and we are sure that in the next couple of weeks, we'll be able to do due justice to this sector of law, right? And I hope that everyone who is going to be joining in for this course is going to benefit immensely from the program and what we'll be getting to learn within the sessions. So my name is Dennis Williams. I will be your moderator for today, and I'll just give us a breakdown of what we are going to be doing today. So usually in the medical health tech and law class, what we usually do is that we start off by introducing the mentors that will be in class. We read out their profile so that you can get to know the people who will be taking you in the session. You can get to see their qualification and overall see the work that they are doing. And then after that, we usually take presentations from the mentees. All right. So after reading the profiles of the mentors, we take the presentations of group one and group two. And please, if it is possible, right, let everyone who is supposed to be presenting be on standby because once I'm done reading the mentor's profile, I'll be calling you up to present from one group to the other. So please let's get set. Um, Try and contact your group presenters, your backup presenters to make sure that everyone who is supposed to participate in a particular role is set for it. And then we will be taking feedback from the mentors and it be discussed for today. In today's session, we have two mentors. I'll be going through their profile very soon. And then after the discourse and feedback from the mentors, then we take questions, take pictures, and then call it a day. So that is the way we run our classes, and I trust we'll be able to assimilate very well into the session. So going straight into the business of today, I will be starting off by reading out our mentor's profile. And first and foremost, in today's session, we have Mr. Ebenezer or Barrister Ebenezer Edwards. So thank you so much, sir, for joining Barrister. Mr. Barrister Ebenezer has been a core key part of this particular health tech program. He has helped us in several mentorship programs, run through the core principles and aspects of this area, and we are grateful and we are glad to have him in this particular session. So Mr. Ebenezer C. Egwatu, Esquire, is a legal practitioner, medical law consultant, certified mediator, trained arbitrator, legislative drafter. I think I'm reading an old profile. Sorry. Okay. Sorry about that, but I think I'll just stick with this. I think there's an updated profile. Sorry, sir, I didn't have access to the updated profile, but let me just go ahead. Legislative drafter and passionate patient rights and safety advocate. He is the principal partner, law firm multidisciplinary consult, a law firm that provides innovative legal solutions located in Abuja, FCT, Nigeria. He is the founder and executive director of Lawyers Arise for the People Initiative, a patient rights and safety advocacy NGO, as well as a Safe Health Medical Legal Consultants Limited, a consultancy and capacity building firm. He is a member of the Nigerian Bar Association, member Medical Law Professionals Association of Nigeria, member Institute of Medical and Health Law, member Bioethics Society of Nigeria, member World Association of Medical Law, and member Association of Legislative Drafters and Advocacy Practitioners. Ebenezer is a trained medical care assessor, by International Medical Law Center, St. Kitts, North America. That is in the year 2019. He was he was certified. He is also a certi- he also has a certificate in policy development and advocacy for global health, a certificate in project management in global health, both from the University of Washington in 2016. He served as associate editor of the book Patients' Rights Violation in Nigeria, a Dex review of health-related law in Nigeria. In 2023, he served on the committee that fine-tuned the National Patient Safety and Care Quality Policy and Implementation Strategy 2024, which was launched by the Federal Ministry of Health and Social Welfare on the 17th of September 2024 through his NGO. He has trained over 120 nurses, over 200 doctors, and over 180 nursing and midwifery students on promoting patients' rights and preventing medical negligence. He currently serves as the chairman, Medical and Health Law Committee, Nigerian Bar Association, Garki Branch, Abuja, the Public Relations Officer, Institute of Medical and Health Law, the Secretary, Training Committee, Institute of Medical and Health Law, and the legal team lead for Make Our Hospital Work campaign, a citizen-led community-based advocacy to improve the quality of healthcare services in hospitals and primary health facilities across Nigeria. Ebenezer is a conference speaker and trainer. He trains doctors, nurses, and other healthcare professionals on patient-centered care, promoting patients' rights and safety, preventing medical negligence, and protecting/strengthening health institutions. He is an avid reader, a researcher, and loves to serve God by serving humanity. So you see the quality of mentors that are going to be taking us in class today. Please let's all welcome Mr. Ebenezer. Thank you so much, sir, for joining. Secondly, we have on call Mr. Emmanuel N. Ogun Ogunnewi. Sorry, sir, if I didn't get the pronunciation of your name properly. Please, you can help just prompt me rightly when you will give you the floor, sir. So, Mr. Emmanuel
My surname is Ogunewe.
Ogunnewi. Okay, thank you very much, sir. Okay, so Mr. Emmanuel holds a master's degree in health law and ethics that's from the UK. He was called to bar in 2006, after which in 2007 he joined the defunct Diamond Bank PLC, where he started his career and rose to the rank of relationship manager slash head of revenue unit Abuja until 2015. Emmanuel qualified as a chartered secretary and administrator in 2014. In 2016, he joined the UNIC law firm to refresh his memory in legal practice under the guidance of the principal solicitor, Dr. Nicholas I. Ude. In acknowledgement of his active legal practice and commitment to litigation and corporate practice, the Chief Justice of Nigeria approved his application and nominated him for the position of notary public, and in 2021 he was sworn in by the Chief Judge of the High Court of the Federal Capital Territory, Abuja. Emmanuel has developed interest in healthcare practice, particularly in clinical/professional negligence, employment law, and immigration law. With his financial, legal, and corporate experience, Emmanuel has garnered skills in commercial awareness, critical thinking, problem solving, paying attention to details, teamwork, and multitasking, and deeply poised to accomplishing tasks with integrity, maintaining standards, best practices, and keeping to corporate governance are Emmanuel's goals in every task he is delivering. Emmanuel is currently resident in England and a member board of trustees of Nottingham and Nottinghamshire Refugee Forum, a renowned charity in the United Kingdom. In his spare time, Emmanuel loves to stay with his family and enjoys discussion around health and politics. Thank you so much, Mr. Emmanuel, for joining in all the way from the UK. We are very, 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 very much happy to have you in this session. So, like I said, In today's class,
Thank you for
we
having me.
normally. Okay, thank you very much, sir. So, like I said, in the class, we usually take presentations from the mentees first, and then give the mentors the opportunity to do a deep dive into the topic for today. So, while our mentors wait for us to get them on board, right, we would like to take presentation from the mentees. So, Group 1 and Group 2, we hope you are set for your presentation. Kindly do well to start your presentation. You all have 15 minutes each for your presentation. So Group 1 presenter, if you are with us, we would like to get your presentation. If the Group 1 presenter is not here on the call, we would be taking presentations from Group 2. Is the Group 1 presenter with us? Okay, while we are waiting for Group 1 to respond, please, Group 2, you can kindly step in and start your presentation. Please, let's be snappy, right, so that we don't spend so much time. If you need assistance sharing your slides, I can do that from my end. Just let me know if you do.
Okay, so good afternoon, sir, and good afternoon, everyone.
Good afternoon, Olua Mayowa.
I'm the presenter for Group 1, and I would need a slides.
All right, just give me a minute. Let me bring it up.
Okay, sir, thank you so much, sir.
All right, so can you see my screen?
Yes, sir. Thank you so much, sir. So we'll be starting from slide 2. Yes. We're talking about the medical health technology in the public sector. Medical health technology law, regulation and compliance in the public sector. Please, can you hear me?
Yes, I can hear you. Sorry, I
Yes, we
just had
can.
an issue with my screen.
Okay, thank you so much. Thank you so much. So, can you still?
Sorry, I'm just experiencing a little challenge sharing my screen, but I would make sure to retry.
Okay, sir.
Okay. Yes, please go ahead.
Yes. Thank you so much. Now, health technology refers to the digital tools used in healthcare delivery. It includes the software, we have the hardwares, we have the AI, we have the medical devices developed to improve the healthcare system, support health practitioners, and ensure patient safety. That is in terms of, how do I put it? In terms of data privacy and the likes. So now we have examples, some of which include the telemedicine, we have the electronic health records that is used in, I think, easy access to the patient's records. And then we have nanobots, amongst others. So these digital systems are relied heavily on by the public healthcare sector. Please confirm if you heard me right.
Yes, we are here.
Okay, thank you so much. Now to slide 3, we have the health technology law. So now these are laws that are put in place to govern the development, the management, and the use of technology in ensuring patient safety. So this ensures accountability, that is in the delivery, and is strongly applied in healthcare institutions. These are the laws put in place to ensure that the technology, the methods in applying technology are complied by, to confer compliance, let me put it that way. So now we move to slide 4. That is on data privacy and protection. Is it? Data privacy and protection. Thank you. So now health data is regarded as sensitive and is protected by the Nigeria Data Protection Act 2023, that is here in Nigeria. So it provides that processing such data should have lawful basis, ensuring confidentiality and protection of the patient's safety. That is, the health practitioner should not just they should not just have access to the patient's data, their information, anyhow. So it protects the data privacy, ensuring confidentiality. That is, it should not be released to the public without the patient's consent. And then the protection of the patient's privacy. Like we know that Section 37 of the Constitution provides for the privacy of the citizens generally. And yes, even patients are entitled to their privacy under the Data Privacy Act, Privacy Protection Act. So now we have the telemedicine regulation. So telemedicine is the easy access to healthcare via internet. Yes, telemedicine provides easy access to healthcare via internet. And so it provides access to healthcare in rural areas, that is not so developed areas, people who don't have easy access to hospitals and other public healthcare institutions. They can easily go online and they have easy access to the healthcare system. However, it raises issues regarding licensing and jurisdiction. That is, you don't know who is behind the computer, you don't know who is behind the AI, you don't know how licensed the person is, you don't know where the person resides. So it raises issues regarding licensing and jurisdiction. And so even if something goes wrong, we don't know who to hold responsible. We don't know who will be liable for misdiagnosis. Yes. And then there is need for a clear regulatory framework in this area. Maybe there should be a regulation providing that the information of the people behind the technology should be provided in, I'm just citing an example actually, should be provided alongside maybe when you are downloading the application or something. I hope you understand what I'm trying to say.
Yes, please, you can go ahead.
Thank you so much. Now to the next slide. Artificial intelligence in healthcare. So artificial intelligence is used in radiology, cancer detection, and predictive analysis. That is, in analyzing medical images. Then it helps with early cancer detection. And then it is used to identify potential health risk. Then now, who is liable for the AI's error? Who will be held liable? Like I said before, we don't know exactly the people behind the technology. There are very, very few technology which we know the people behind. We don't know the developers. We don't know who is managing the technology. And it is what is, how do I put it? It is what the developer has instructed the AI to provide, that it is going to provide. So yes, this leads us to saying that it raises concerns about the algorithmic, I don't know if I pronounced that very well, algorithmic bias and transparency. So we don't know where the person is coming from. We don't know the jurisdiction the AI has been tailored to. Like, for instance, we know the weather here in Nigeria is different from the weather in some other countries. And what if the disease is caused by weather? I'm just citing an example again. What if the disease is caused by the weather, and then the AI is tailored to maybe provide diagnosis based on the weather in Canada or something? We know how cold Canada can be and how hot Nigeria here can be. So now that's that. So to the next slide, please. So now we have the medical ethics principle. We have autonomy, that is the respect for patient's choice. There are some instances where the patient should have the freedom to select or to choose whichever treatment they want to pick. I think, for instance, we have in terms of we have breast cancer also, where they are told to choose between, I don't know, scratch that. So now we have beneficence, to act in the patient's best interest. How do I put that? Even as lawyers, we are to act in our client's best interest. So the medical practitioners are also to act in their patient's best interest. They should not do something that is against what favors the patient. Then we have non-maleficence, to do no harm. I don't know how to explain that very well. Then we have justice, fair and equitable access to care, irrespective of the color or the sex, or you don't have to tell a Black person to, you don't have to delay the Black person's treatment and then provide treatment to white people, or to delay the women and provide treatment to the men, or to delay the men and provide treatment. Be fair and equitable in all areas, including the healthcare sector. Now, the next slide, please. Now, ethical concerns in digital health, digital consent and patient's understanding. How do I explain that? Okay, so in how do I put this? So digital consent and patient's understanding. The patient should have full knowledge or understanding, at least to the extent to which the patient can understand, on what the person is about to undergo. I don't know if that tallies or rhymes with what is going on here. And the person should be able to consent to the treatment. I don't know if. Then equity and access gaps, and then we have the confidentiality risk due to cyber threats. Please, the next slide. So now, regulation in public sector. Different areas of law, different laws have been provided to protect the patient's rights and to confer compliance on the health practitioners. We have the medical and dental regulation or act, medical and dental act. We have the data protection and Nigeria Data Protection Act. We have several other acts like that. So now the Ministry of Health should provide oversight and regulate these sectors in the public sector. Please, the next slide. Compliance requirements. Adherence to the data protection laws. So if the patient's data gets, shared to the public without the patient's consent, it is unlawful to do that. So there should be cybersecurity safeguards. Then there should be professional licensing compliance. The professional or the health practitioner must be licensed in order to have access to the patient's data. Then we have the regular audits and monitoring. Please, next slide. So now, case study examples: data breach in the public hospital system, AI diagnostic error leading to patient's harm. So here now, who would be held liable if the AI does something wrong? Then telemedicine dispute across state lines, like we already mentioned, different jurisdictions can create issues regarding telemedicine and even AI. Please, the next slide. Challenges in developing countries. We have the weak enforcement mechanisms. So now, limited cybersecurity infrastructure. Not all countries have the cybercrime law. Not all countries have professionals. People are professional in cybersecurity. So in such countries, the where the patient's data is not provided, is not protected, for instance, where a patient's data is released to the public without the patient's consent or unlawfully, then in such countries there's no measure that can be taken per se, because you can't say exactly who released this data to the public, especially since we're talking about the technology aspects. So now, funding constraints. These medical devices they are expensive, and not all developing countries can provide for them. Not all developing countries have that amount to fund all these medical devices. Then low digital literacy. There are very few countries with digital literacy. For instance, most African developing countries are used to the paperwork. They are not so intelligent when it comes to technology. So these are challenges developing countries face in terms of technology generally, not even restricted to the health sector. This is the next slide. So now we have the recommendations. We have to strengthen the enforcement of the health data laws. That is to confer compliance on both the health practitioners and even the patients to an extent. Then to develop AI specific regulatory framework. That is, like I said before, maybe they should provide access to maybe knowing the people that develop the technology and the likes, in order to know who to even hold responsible if something goes wrong with the AI. Then mandatory cybersecurity audits. This even goes to the people who have the cybersecurity, who have knowledge on cybersecurity. And then improve digital literacy and training. Yes, the knowledge on how to operate these medical devices should be provided to the medical practitioners in order for them to be able to operate these medical devices in a way that would not cause harm to the patients themselves. And please, the next slide, if there is, then conclusion. Now, the health technology improves public health delivery. That is, it improves the healthcare system. And then the laws ensure accountability. That is, it confers compliance. It holds people, the defaulting practitioners, liable. Then ethics ensure fairness and dignity in the health sector. Then there's the regulation and compliance ensure sustainability. And that will be all from me. Thank you so much.
Very much, Oluwamayowa, for helping us with your presentation on behalf of your group. We'll be taking presentations from group 2. So please, group 2, let's quickly take your presentation. Please, let's try as much as possible to stick to time. The time for the presentation is 15 minutes, right? So please, let's get to it. Group presenter, you can go ahead and share your slides. If you need help with it, I can help you with that.
Okay, good afternoon. So please, I'll be needing help in sharing my slides.
All right, so a moment, let me quickly do that.
Okay, thank you, sir. So,
Yeah.
good afternoon, distinguished mentors and colleagues. My name is Sophia Onwara, and I'll be presenting for Group 2. My topic is on health technology law, medical ethics, regulation and compliance in the private health sector in Nigeria. Okay, next slide, please. Okay, so first of all, health technology includes telemedicine, electronic health records, AI diagnostics, health apps, and medical devices. So since the advent of technology, it has helped the health sector a lot in introducing things like telemedicine and electronic health records. And then the private health sector consists of private hospitals, clinics, labs, HMOs, that's health maintenance organizations and digital health startups. And then law and ethics ensure patient safety, data protection, and accountability. So health is an important sector in our country, as we all know. And health technology is basically, there are laws, regulations that help to ensure that patients are safe and that health providers are held accountable and they do things by the book. So next slide, please. So like I previously said, the health technology law are basically, it's basically a body of rules that govern the use of technology in healthcare. It regulates licensing, ensuring that they are qualified doctors or health providers. It protects the data of patients. It also regulates medical devices used within the health sector and professional conduct between health providers and patients. And it also balances innovation with patient rights and safety. Next slide. So in Nigeria, there's not just one body of law. There's not just one legislation governing the regulation of health technology in Nigeria. So there are many institutions. A few of them are mentioned here. Federal Ministry of Health, they help with policy making and oversight. Then there's the Medical and Dental Council of Nigeria. It's in charge of licensing doctors. Then there's also the Nursing and Midwifery Council of Nigeria, in charge of nurses and midwives. And then NAFDAC stands for National Agency for Food and Drug Administration and Control. They're in charge of drugs and medical devices regulation. And then there's National Information Technology Development Agency. They're in charge of data protection. Thank you. Next slide. Okay, so medical ethics and private health technology. So the health sector, there are four, or should I say core, um, five core, um, five core things that health providers are supposed to have in mind. First is autonomy. Autonomy simply means that the patient has the right to decide whatever treatment that they will be getting. So they have to give consent before their data is collected or before they are treated. They have a right to know what treatment they are getting, and then they can turn it down or they can accept it. You don't force a patient to take a particular treatment, no matter how well intended it is for that patient, but they have a right to say, no, I don't want this. Then confidentiality, it involves the protection of the patient's health records. It's not supposed, the patient's records are supposed to be kept secret between the health provider and the patient. It's not supposed to be out there. So then the third one, beneficence. It basically means that health providers should act in the patient's best interest. Yes. And then non-maleficence is somewhat related or closely related to beneficence, only that this time, instead of just acting in the patient's best interest, non-maleficence is about not doing harm or doing anything that would unnecessarily expose this patient to harm. So we need to use safe AI tools. AI tools that have been regulated, that we have done that. Safe AI tools, basically tools that are we are sure that would not cause necessary harm to the patient. Then justice, the final one, involves equal access, no discrimination towards patients. Next slide. Okay, so we have the regulation and compliance in private sector. So when we talk about regulation and compliance, we simply mean ensuring that these health institutions comply with the law stipulated. So private hospitals must be licensed by state health authorities, for example, Federal Ministry of Health. Then telemedicine platforms must ensure qualified practitioners because, I mean, over digital devices, you're not sure of whose qualifications. So it's up to some certain institutions to ensure that the practitioners that will be on those telemedicine platforms are qualified practitioners. So we don't expect that patients should be worrying about their health and then worrying about the qualifications of the doctors who will be treating them over these platforms. Then compliance with Nigeria data protection regulation. So they have to do things in accordance with the law. And then medical devices must be approved by NAFDAC to ensure that they are safe for use. And then the sanctions, if they do not comply with these rules and stipulations, include that they may be forced to pay fines, in worst cases, suspension and closure. Next slide, please. So we have the case study. For example, if to show you just how important that health technology law is, this case study here talks about data breach. So what happens in the event that there's a data breach where the private hospital's patient database is hacked? So the legal issue here is that there's been a breach of the NDPR, which is the regulation protecting the data rights of patients. So the legal issue here is that they failed to protect personal data. And then the ethical issue here is that there's been a violation of confidentiality because their records are out in the open, other people have access to them. And now the consequence here would be regulatory fines and loss of trust, reputational damage, because the patient would be distraught, would feel betrayed, and then also on the part of the hospital, they'll be forced to pay fines for such things, especially if the patient moves to sue for this problem, for this scenario here. Yes. Next, please. Next slide, please. So case study 2, unlicensed telemedicine practice. So this scenario here talks about online platform employs unlicensed doctors. So remember earlier I said that patients cannot worry about their health and also have to worry about the qualifications of the doctors treating them. So unlicensed doctors, some of them who have not been passed through the medical dental council, they might just want to take up the job of, helping out patients when they've not been licensed or they don't have the backing of the law to do so. So here, the legal issue here is violation of Medical and Dental Practitioners Act. Then the ethical issue here is a risk to patient safety. Yes. And then the possible outcome would be platform shutdown also and practitioner sanctions. Next slide. So the challenge is with the health tech law in private sector. There are weak enforcement of regulations. The problem isn't creating laws or rules or regulations, but the issue here lies with the enforcement. So there are enough regulations and all, but then the enforcement mechanism is very weak. So that's a problem. And the second one is limited digital literacy among patients. Many patients have little to no idea about these devices, how to use them, how to access them. And then there is high cost of compliance for startups. So, and then the next challenge is that they find it difficult balancing innovation with strictly regulations. There are regulations, but they are stringent, and then it sort of stifles innovation and growth in the private health sector. Next slide, please. So, in conclusion, health technology improves healthcare delivery in the private sector. It's made things easier, made things more effective, efficient, but we also need strong legal and ethical compliance. It's very necessary to protect patients. And the regulations, the rules here are to protect patients while supporting innovation. Yes, so while health technology is good, but we still have to find a way to balance protecting patients and supporting innovation. Thank you very much for listening to my presentation.
All right. Thank you very much, Sophia, for presenting on behalf of your team. We will not waste any time. We'll be heading over to our mentors for them to share their thoughts on the presentation, and not just share their thoughts on the presentation, but also will discuss, like we had planned, discuss overall the topic for today. The topic for today is health technology law about compliance within the health technology law space. So, Mr. Ebenezer, welcome, sir. Thank you so much for joining. Please, sir, if you can hear us, I want to give you the floor first to
Okay, thank you very much,
on the
Mr.
topic for
Dennis.
today, and also what you would like to share with us in class.
Can you hear me? Hello, good evening, everyone. Please confirm that you can hear me.
Good evening, sir. We can hear you.
Yes, please.
Okay, thank you very much, Mr. Dennis and JIIPCC. It has been a robust partnership of many years and many more years to come. Let me also extend my greetings to my co-facilitator or mentor in the person of Mr. Eman. I am trying to get anywhere. I hope I go second order. Thank you.
Yes, Mr.
Okay,
Dennis,
firstly, let me congratulate. Thank you, sir. Let me congratulate all the participants. Mr. Dennis, how many participants registered and how many are on the call? Hello, Mr. Dennis, how many participants registered and how many are on the call?
Yes, sir, I'm just trying to. All right, so let me try and give you the rough number that we have on the group. We have about 17 participants that registered, and we have, I think, about 10 of them on the call.
Why are the other 7 not here? We need to find out. Okay, let me congratulate all of you that have registered for this program. You may not fully understand what you have done for yourself at the moment, but with time, maybe in the next 2, 3 years, 4 years, you will get to understand. By that, I mean you are plunging in and taking a head start in the medical legal space in Nigeria, because medical law practice in Nigeria is an evolving area of legal practice. Not too many lawyers are in this area of practice, not too many lawyers. Then it is not about being a senior advocate of Nigeria, with due respect to every one of them. It is not about being a senior lawyer, with due respect also to all of the senior lawyers. It is about specialized knowledge. It is about technical knowledge, and it is about expert knowledge. So I want to welcome you on board, and I take pride in the fact that I'm among the first to midwife you into this area of practice. My usual style, I would have told you all to on your camera and introduce yourself, but the time is brief. I won't do that today, partly because I'm not feeling too strong. That's why my own camera is not on. But from next week, when we come to class, your camera needs to be on. Okay, I want to commend the two groups that have presented. Judging from the fact that you are rookies, you are coming in, this is your first contacts, and you could do this depth of research. So I commend both of you. So let's look at what medical ethics is. Let's start from there. None of the two groups bothered to define for us what medical ethics is. None of the two groups bothered to define for us. They just, from the head knowledge, fine, okay, we understand. But this is an academic class, so can we be a little academic? Normally, medical ethics will refer to the body of morals. Once you hear ethics anywhere, you are talking morality. To refer to the body of moral principles, values, and rules that govern the conduct of medical practitioners while discharging their professional duties. Now, these principles will come to play when questions arise, especially where there are competing interests, where the value issues arise, where a patient the doctor wants to continue treatment. The patient says, I don't want to continue treatment. What should we do? That's where the things we are talking about come up. Now, that should be August. Around October, November last year, I got a call from Lagos. Somebody, a lawyer too, he made a request on a platform who is into medical law practice here, and they referred him to me. What was the issue? A woman was hospitalized. Each night on that bed is costing 1.5 million. She's aged. She has been on life support. Her family said they can no longer do. They want to terminate. They want to discontinue treatment. And the hospital say, no, we cannot discontinue treatments. You have to go get court order before we can discontinue treatments. Now, these are real-life examples of medical ethical issues. Yesterday afternoon, because I want us to relate with it. I don't, it's an everyday occurrence. I don't want us to make it look esoteric or theoretical. I want us to bring it home, relate with it practically. Yesterday, I read on Facebook, a woman is pregnant. The doctor has told her she needs to deliver via CS. Her husband and family say, no, our religion and tradition forbids delivery via CS. So woman, if you want to deliver via CS, you run the risk of losing your marriage. You can deliver through CS and go to your mother's or father's house from the hospital, or you do natural delivery and retain your marriage. And the woman was asking Facebook people, please help me. What should I do? Now, this is a different thing entirely. We have issues of blood transfusion. Somebody comes to hospital and says, my religious belief does not allow me to receive blood. So the hospital doctor says, we must transfuse you if you are interested in being alive. So which principle governs these decisions? Because they are all life-threatening. That is when we are referring to ethics, medical ethics. However, from the legal perspective, medical ethics, it has gone beyond moral persuasion. We said it's moral principles, values, and all that. But talking legally now, because we are discussing medical law, health law technology. So it is not just the medical alone. There is a legal component to what we are doing now. So legally speaking, it has gone beyond moral persuasion. It has taken a form of a norm, a form of a legal obligation. Why? Because there are some legal statutes, there are laws that has made them mandatory and obligatory. So it is no longer what the doctor wishes. It is no longer the moral persuasion of the doctor. They are now legal obligations of the healthcare professional. Because if we look at the code of, if we look at the Medical and Dental Practitioners Act, under which, from where we derive the Code of Medical Ethics. Now you see that these are laws. Some are regulations. We look at the National Health Act. We look at our Constitution. We look at every other health legislation. You will see pockets, directly or indirectly, of these ethical principles, stated obviously or overtly as one or impliedly. But they are all summarized in the 4, 5 this thing we have mentioned. Number one is autonomy. The principle of autonomy. When you say this, the patient is the Lord and Master of his body, the patient determines what shall happen to his body. You do not understand the far-reaching effects until you hear some judicial pronouncements. Then you will understand the far-reaching effects or how powerful. Now, when we talk patient's autonomy, it is that the doctor, the nurse, the healthcare professional must respect the wish and desire of the patient as far as treatment of the patient is concerned, as far as whatever concerns the patient's health and body is concerned. It does not matter the best of interest the healthcare professional might have. Okay. Now, let's look at the case of Sklendorf against Society of New York Hospital. It is a 1914 case. In that case, referring to autonomy, Lord Cardoso held that, he said, every human of adult years and sound mind has a right to determine what shall be done to his own body. What shall be done to his own body. And a surgeon who performs an operation without the patient's consent commits an assault for which he is liable in damages. So, assuming there's emergency and they rush the patient to theater and the patient try and says no, he doesn't want surgery. No matter how much the hospital wants to save his life, the rule of autonomy says that the patient should not, the hospital should not proceed. That's the principle of autonomy. Let's look at a Nigerian case, Medical and Dental Practitioners Disciplinary Tribunal against Okonkwo. In that case, the Supreme Court held a patient's right to refuse medical treatment on grounds of religious belief was recognized and duly upheld by the Supreme Court of Nigeria, thereby absolving the doctor who did not transfuse blood to the patient from professional misconducts. Now, in this case, the patient belongs to a particular religious sect. They say they do not receive blood transfusion. Now, this patient wrote it that she does not want blood transfusion. She had been in a different hospital, received care, then said she doesn't want blood transfusion. That doctor said, Madam, if you do not want blood transfusion, there is nothing else I can do other than to transfer you. She was referred to another hospital. They came there, made the same statement. They don't want blood transfusion. In fact, she even wrote it down. She doesn't want blood transfusion. The doctor, in obedience to her desire, did not transfuse blood. Eventually, the patient died. The mother of the patient and the husband sued. They dragged the doctor to Medical and Dental Council. His license was suspended and he appealed. the Court of Appeal overturned the decision, and it went to Supreme Court. Medical and Dental Council went to Supreme Court. And this was what the Supreme Court said, that a patient has a right to refuse blood transfusion. We are still talking about autonomy. To refuse blood transfusion as far as it concerns his body, whether it is religious reason or whatever reason. Now, those religious, some of them, they carry cards. Some we say do not transfuse, some we say do not resuscitate. So the proper thing to do is, where maybe an accident victims are rushed to hospital, the first thing to do is to search them to see whether there is such card in respect of the principle of autonomy. Now, one of the rights of a patient, we still treat patients' rights. One of the rights of a patient is a right to refuse treatment. And it is from this principle of autonomy that right is derived. Now, let me give you a funny decision of court. In Sidaway against Board of Governors of Bethlehem Royal Hospital, it's a 1985 case. The court held a patient is free to decide whether or not to submit to treatment recommended by the doctor. If the doctor's making a balanced judgment advises the patient to submit to the operation, the patient is entitled to reject the advice for reasons which are rational or irrational or for no reason. So the patient does not owe the doctor explanation as to why he or she is refusing treatment. So once the patient, of course, the condition here is that the patient must be a person of sound mind. First, the patient must be an adult and a person of sound mind, and the consequences of his decision would have been communicated to him. Once these three factors requirements are met, the doctor has no case to answer. Then we look at the principle of beneficence. Do good. Act in the best interest of your patients. When you are acting, when you are taking decision, let the decision be in the best interest of your patients. Prior to now, what used to be obtained in medical practice is what we call the principle of paternalism. Now, paternalism is where the doctor makes all the decisions for the patients. The patient has no say. It's the doctor that will decide whether the leg will be amputated. It's the doctor that will decide whether there will be surgery or not, regardless of the patient's opinion. Now, this principle is saying make decisions in the best interest of your patients. Now we have, or it is gaining prominence, which is self-determinism, which is anchored on autonomy, where the patients now decide what they want. But the principle of beneficence is that your decisions will be in the best interest of your patients, not just the service your hospital will provide. For example, a patient presents a case. Now, under a patient's, one of the other rights of a patient is rights to information. And under that right of information, a patient has a right to know the nature of his ailments. One, he has a right to know the treatment options available, not just the treatment option the healthcare facility can provide. So, where there are options A, B, C, D, and options B to D are less expensive, we cause less harm to the patients, and the patients can recover quickly. Unfortunately, your facility can only offer option A, which is more expensive to the patients and can keep the patients more on a wheelchair or a bed, hospital bed. The principle of beneficence requires that you, the doctor, we decide to refer the patient to another facility that can provide options B, C, or D for the patient. So your decisions must be in the best interest of the patient, not just because you want to make quick money. Then we look at another very important principle, the principle of justice. The principle of justice refers to equitable distribution of available resources. The example I usually give is when we had the COVID pandemic, ventilator became a serious issue. Hospitals, a lot of hospitals didn't have it. The few that had it, it was basically preserved for the rich. So the principle of justice is saying that if two people are rushed in with COVID and the poor man is more in need of a ventilator than the rich man, the principle of justice says that you should put that poor man on the ventilator because it is equitable distribution of available resources. You do not say, okay, this one is a nobody and this one is a senator, even when his case really has not reached the extent of putting him on a ventilator. You now go and put him on a ventilator and watch the other poor man die. You are abusing the principle of justice. Another scenario is where people go for delivery, particularly general hospitals. You go there, you see people from diverse economic background. In fact, some from their outfits, merely looking at them, what they are putting on, the nature of their makeup, the phone they are carrying, you can assess basically the level of this one economically. So you do not neglect the needs of those ones who are lesser economically in the society, and begin to attend to the wife of the Senate president, the wife of the deputy governor, the wife of your local government chairman, knowing that at the end of the day, something will drop for you. That person is abusing the principle of justice. Then the next principle is the principle of non-malfeasance. Do no harm. Now, the Hippocratic oath, that's the oath that healthcare professionals, medical doctors take when they are conducted. It is contained there. They will not use their expertise. They will not use their knowledge to do harm. So beyond theory, it's an oath that have taken that they will not use their medical knowledge to do harm. Now, cases of outright medical malpractice, I'm not talking medical negligence. Cases of where people go to hospital and a patient's kidney is stolen. I mean, a patient comes to hospital for one treatment or surgical procedure, but has nothing to do with the kidney. That patient's kidney is harvested without the patient's knowledge. One happened in Ekiti State. In fact, they took the two kidneys, thinking that he would die. But God had a way of sustaining him and keeping him alive. That was how that case came to limelight. The Ekiti State government had to intervene to provide another kidney for that young man. So that is a classical case of abuse of the ethical principle of non-malfeasance. Do no harm. This afternoon or this morning, earlier today, I stumbled on a video. I will drop that video on the platform on Facebook. Now, my annoyance with that video is that the perpetrators are trained and certified lab scientists. They are into blood buying and selling. One will just go to all these drug addicts, go and buy blood from them. without screening it, then sell to another one who is practicing and using the medication, using the drug to treat patients, using the blood to treat patients. Police arrested them. And when they were being interviewed, both of them are certified lab scientists. You go and take blood from known drug addicts. You didn't run tests. You didn't screen those blood. You package it. Then another person, in fact, the funniest part is that the person who was doing the racketeering is using a hairdressing salon. I will post the video on the platform. Now, that's a classical case of doing harm to a patient. And it runs contrary to that principle of non-malfeasance, do no harm. Now, how are these principles? I've tried to make them relatable as possible. How do these principles come to, how do we apply them in everyday situation? Because that is where these principles are behind. You won't see them written on the hospital board. You won't see them written in the theater. They are inside the brain of the patient, of the doctor. As he's interacting with the patient, he knows these things. He knows this. But the only way you now being trained as a patient, as a medical lawyer, the only way we can, because we talked about, a lot of you talked about enforceability. The only way we can maintain enforceability is when patients are educated, and where these rights or ethical principles are violated, the patients come out to press and seek legal redress. It is in testing these things in courts that the court will begin to make pronouncements such as I have read out for you. So that is that on ethical principles. Just know that beyond being moral principles and obligation, metamorphosed into legal duties, because regulations have provided for them, laws have also provided for them. So they are no longer obligatory, or if the doctor wishes to pity the patient, he will just apply the principle of justice. If the doctor really likes the patient well, he will apply the principle of non-malfeasance or respect his autonomy. No, they are now rights. They are now rights be demanded and enforced. Now, if you look at the principle of justice, it is also anchored on section 42 of the Constitution, talking about discrimination. So the example I gave of a rich man and a poor man needing ventilator, the preference of a rich man to a poor man is discriminatory to the poor man who urgently needs the ventilator. So you see that these ethical principles, they are rooted in different laws. They are rooted in different laws. Okay, quickly, let us look at telemedicine. What is telemedicine? Because telemedicine, it is coming up every day, telemedicine. What exactly is telemedicine? One of the definitions of telemedicine, according to European Commission, says that it is the provision of healthcare services through the use of information and communication technology, ICT. So if you are providing healthcare services through the use of ICT, especially where distance is a barrier between the healthcare provider and the patients, you are practicing telemedicine. Then WHO, almost a similar definition, defines telemedicine as the delivery of healthcare services at a distance using electronic means for alignment, diagnosis, prevention, and treatment of illness. So, firstly, one is there's a distance between the patient and the doctor, and we are now trying to use technology, information communication technology to bridge that gap. For you to be discussing telemedicine, we must look at 4 elements around telemedicine. One, what is the purpose? The purpose of telemedicine is to provide clinical support. 2, what is it intended to? To bridge geographical barrier, connecting users who are not in the same physical location. It could be used with different types of ICT. Now, most importantly, the primary purpose of telemedicine is not necessarily to make money, even though our people, everything is business. It is to improve health outcomes. Of course, money will come in, but the driver of telemedicine is to improve health outcome. Okay, so for time's sake, let's look at the different types or categories of telemedicine. You have the store and forward medicine, telemedicine. This one is the electronic transmission of patients' medical information. Maybe a hospital had treated a patient in Nigeria. The patient has gone to US for further treatment. And you now have the medical information. Before now, you will have to fly back to Nigeria, carry hard copy. Or maybe years ago, they can do telex and send you. But now, whether it is lab reports or whatever, in minutes, you can get the case file, real time. There is telemonitoring, which is continuous monitoring of the process of the development of the patient's healthcare. Then there is real time, where the patient and the doctor are engaged one-on-one, talking real time. Now, we look at regulation of telemedicine in Nigeria. It is a big challenge and pathetic that in 2026, we do not have a national act, a law that regulates telemedicine in Nigeria. I am aware that Lagos, as usual, is already taking steps to regulate telemedicine. At the national level, there is no law. There is a bill before the National Assembly. It has not been passed into law. But in Lagos State has a HEFAMA, and HEFAMA, how many of you have heard about HEFAMA? Now, HEFAMA is Health Facility Monitoring Accreditation Agency. Okay, you have, good. You should know, So, HEFAMA is Health Facility Monitoring and Accreditation Agency. It is the principal regulator of health facilities in Lagos State, including those that offer telemedicine services. What Lagos has done is they are even saying, if you want to do telemedicine, you should still have a physical office where people can walk in and consult. So all your practice as a telemedicine practitioner should not be in the air and invisible. No, you should have a physical office where people can come. In fact, that's your office. They have a list of equipment that must be in that your office before you are licensed to practice. Now, you do your annual registration, or when you do mandatory registration. After that, every year you renew your registration. There are key different licensing. You're going to do professional licensing. You're going to do data privacy. Of course, the business has to be incorporated with CAC, your consent form, your drug regulation, everything. They must look at it. And you will need to get, depending on the category, you will need to get a certification from NAFDAC and the Pharmaceutical Council of Nigeria. Now, when you were saying, I think it's group 1, they were saying if there is misdiagnosis, who will be held responsible and all that. They operate as companies, registered companies, with the right to sue and be sued in their capacity, 1. 2, the doctor attending to you is not a ghost or a stranger. One of the rules of engagement, your right to information as a patient, you have a right to know the names of the healthcare professional attending to you per time. So if you book consultation session with telemedicine company A, and they assign Dr. X to you, Dr. X will introduce himself to you. So you now know the name. You know the name of the company that attended to you. So there will always be a way to get your litigation or get redress in your favor. So you do your tax clearance, you must do that. Then they look at your professional staffing. That's Lagos State. They do not have a law yet regulating telemedicine, but what HEFEMA is doing is really commendable and should just be translated into law. When they come to professional staffing, they will look at your operating officer's credentials. Do you have a cybersecurity expert? You will get letter of good standing from your professional body. A medical doctor, you get letter of good standing from Medical and Dental Council of Nigeria to say, yes, we know this one. He's in our good books. He doesn't have any criminal case. We don't have any criminal or any professional misconduct case against him. So you must present their current practicing license. Then, of course, they are required to swear affidavits to show that, yes, they are who they claim to be, and they will not do anything contrary to what they have put out. Then, different registration for different categories. Then HEFEMA will come and inspect your facility. If it meets standard, then they will license you. And there is also routine. The inspection includes the environment, your staff, your equipment, everything. When you meet these requirements, they will license you. And after 1 year, you renew your license by paying again. After another year, you renew. So it is annually. Now that makes it easy to monitor. That makes it easy. So it's not a one-off thing. Now, are there challenges? Very many challenges. One is internet challenge. Internet challenge. There are some remote areas that internet are not available. So the issue of coverage, which was primarily one of the good motives to bridge the gap due to distance. Now, that gap will still not be bridged. That old woman will still have to trek from that village to the main road, enter motor before going to the hospital. That's one challenge. Another challenge is issue of data breach. If you look at section 22 of the Code of Medical Ethics, that's about the only law in Nigeria. Not a law per se, the regulation, that's the only regulation in Nigeria that makes specific mention of telemedicine, and it enjoins doctors to be wary in engaging in telemedicine. Now, we must salute the ingenuity of those who drafted the Code of Medical Ethics, knowing that that code was drafted in 2008, when the internet was not as it is in Nigeria today. So we must commend them for taking that initiative. So it makes mention of telemedicine, and it enjoins healthcare professionals on how to go about it, especially protecting patients' information. It recognizes that data can be intercepted. So it advises doctors who are into telemedicine. Don't forget, this was 2008. Now, I personally believe that the Code of Medical Ethics should be reviewed, and a lot of issues had come up technologically and in other aspects of medical practice, so that it will be incorporated. But we must commend them for as far back as 2008, talking about telemedicine. So they are enjoined to take precaution in ensuring that the data of their patients are protected from being intercepted, either by when sending it as email or when sending it as God help me now, telegraph. So that is that about telemedicine. What are the advantages of telemedicine? In the last set, I think last set or two sets ago, I shared a video on the platform. There's a company in Ghana. They are using robots to distribute medicine. They are using robots. There's another company. They are using robots to send needed organs. Hospital A needs to transplant organ, maybe kidney. Hospital B, the patient is in hospital B, there is a distance. Hospital A opens this man up, gets his kidney, packages it, everything is in working condition, they put it in the robot, fly it to the other hospital. I shared the video with the two sets or so. I will look for that video again. Now, in advanced countries, telemedicine is already doing a lot. There have been intercity surgeries, robotic surgeries, meaning that somebody is in Abuja conducting a surgery in Lagos. I think I also shared that video with them. Somebody is in Abuja using computer to conduct a surgery on a patient in Lutz in Lagos. Now, that's how far technology has gone in advancing medicine. But challenges now for us in Nigeria, regulatory standard, our standard organization of Nigeria. Okay, if you look at all these, how do I call them now? All these wristwatches and other, even your BP apparatus. Now, what is the regulatory standard? Because we still have a lot of them that are below standard making their ways into Nigeria. Telemedicine is good. But if we have standardization, starting with laws, both at the state and national level, then we strengthen our regulatory bodies. We look at, if you look at the provisions of the Cyber Crimes Act 2015 as amended in 2024, yes, it criminalizes certain aspects of maybe interception, identity theft, cyber stalking, cyber bullying, and all that. But there is nothing medical regulating the medical space or the use of patients' data in the Cyber Crimes Act. Now, if you look at our National Health Act, the National Health Act provides for confidentiality of medical records and proper care. In fact, there's even a penalty attached to anybody through whom a patient's data is needlessly put in public space. There's a penalty under the National Health Act. But we need to strengthen our regulatory bodies from we also need to review or, if possible, amend some of our laws, starting with the Cyber Crimes Act. We look at the data protection. Yes, it mentioned data processing in hospitals, but for me, that is still not sufficient. There is need to make them firmer and put stricter punishments where there is violation of those rights of a patient and their data gets into the hand of the wrong person. Thank you very much. I think I'll be stopping here so that my co-moderator will also have a bite of the cherry. If there are questions, I would suggest you put your question at the chat box. Then after his contribution, we take the questions jointly. Thank you.
Thank you so much, Mr. Ebenezer, for your very, very detailed discourse into the topic for today. We sincerely do appreciate, and I trust the mentees who were paying attention in class got a chunk of what you were saying. Please, for the mentees, this class is being live streamed, so you can always go and revisit the class so that you get the full details in case if you missed any parts during Mr. Ebenezer's discourse. But that is not all, right? We still have Mr. Emmanuel in class. Thank you so much, sir, for staying till this time. All right, Mr. Ebenezer has already shared his own thoughts, and he also wants to give you the floor, sir. So also just help us run through what you had in mind when coming to class today.
Thank you, Mr. Dennis. Hello, can you hear me?
Yes, sir, we can hear you, sir.
Yes, we can hear you.
Okay. Good evening, everyone.
Good evening, sir.
Yeah, can you see my
Good evening,
face?
sir.
Hello, can you see my face?
Yes, I can.
Can you see my face, please?
Yes,
Not
we
yet.
can.
Yes, we
Okay.
can.
Maybe from my device.
Okay. Let me start by thanking JIIPCC for this opportunity. And today is the International Women's Day. So I want to extend my special regards to Juliana and all the women participants who are in this program, as well as the team in JIIPCs who are women, that we are so proud of you. As our mothers, as our wives, as our siblings, as our colleagues, we are very, very proud of you. So continue to do the good things you do for us in this generation. God bless you all. Then for Mr. Egwato, I'm happy to connect with you, and I make bold to say that your presentation was well thought out, and of course you know what you're doing, so continue to do the good job you do. Thank you so much.
Thank you, sir.
Yes. My presentation today, I want to share my screen. I don't know if you have been able to get it now.
Yes, sir, we can see your screen.
Yes, sir.
Yes, okay. So the topic is health technology law, medical ethics, regulation and compliance. And of course, my name is there. Then you have today's discussion overview. You have the definition of key concepts, the health law, health technology law, and medical ethics. Then you have ethical issues around the application of health technology. Then you have the dilemma of the principles of medical ethics in the area of health technology. Then you have the key health technology regulators and standards, case study of UK and Nigeria. You can see that for the key health technology regulators and standards and the other highlights, which is cross-border legal considerations in health technology, I decided to use a case study of UK and Nigeria because I discovered that the topic is a broad one that was not specific to whether it is about Nigeria, it is about Africa or the entire world. And because I am seized of the vision of this organization, JIIPCC, that the vision is centered on Africa. So that's why I decided to use Nigeria. And of course, because I live in England, United Kingdom, I say, okay, let me put two of them. Then you have implementing robust compliance strategies to build patients' trust and maintain standards. Then the conclusion and the references. The next slide. You have definition of key concepts. The term health law recognizes there is a relationship between health law and health. And health law, although it had already been stated by the mentees during their presentation, and also Mr. Guato, is a body of statutes, rules, regulation, case law, contracts, and customary laws that guide how health care services are provided, how public health is maintained, and how patients' rights are protected. Then you have the health technology. Health technology, because of time, I may not be able to read through everything that is here. So health technology has become an integral aspect of modern healthcare, influencing the way medical professionals diagnose, treat, and interact with patients. Health technology, simply put, is a modern way of improving healthcare delivery and services. So I think that is exactly what it is. And you see, it's an umbrella term which involves a diverse range of products ranging from over-the-counter consumer devices for health monitoring, smartphone apps, pregnancy testing, to complex robotic surgical systems used by specialist clinicians. Then there are examples of health technology, the tools. You have medical devices, which is used to diagnose, treat, or monitor a medical condition. Examples is the insulin pumps, which those who have diabetes use. You have the pacemakers used to regulate heart rhythm. Then you have the wearable devices, one on the body to track health data like heart rate and activity levels. I don't know if you are looking at this smart watch I have, the smart wristwatch. Can you see me? Hello? Hello?
Yes, sir, we can.
Can you see my wristwatch?
Yes, sir.
Yes. So with this wristwatch I'm wearing, I can use it to monitor my heart rhythm. I can also use it to determine how many steps I have had during the day. So that is an example of wearable device, which is a modern health, technology for healthcare. Then you have the mobile health, which is mHealth. Use of mobile tech like smartphones and tablets to deliver healthcare services and support health management. You have the telehealth, which had already been discussed, delivering healthcare services remotely through video conferencing or phone calls. Then you have telehealth. Like there is a difference between telemedicine and telehealth. While telemedicine centers on medical. Telehealth is a broader term which talks about the modern ways of using ICT, just like Mr. Guatu mentioned, to deliver healthcare services. While telemedicine is restricted to, a part of health services, which is medical. But this one is a broader term, which is delivering healthcare services remotely through video conferencing or phone calls. They have the electronic health records. With the onset of technology, we no longer make use of the analog system. I know in developing countries, the analog system is still there, where if you have need to make reference to the medical report of a patient, you go and bring the file and be looking at it. But in the developed countries, everything is now electronic. That's why from the comfort of my home where I am, I'm connected to my health data from my phone, where I can actually access my medical records, my results, the diagnosis, and the treatments I have received, even the medication that I'm taking. So all these things are the effects of electronic health records. They have artificial intelligence, which is the use of AI algorithms to analyze medical images like X-ray, MRI, CT scans with remarkable accuracy and on time than human practitioners. AI enhances remote health monitoring of patients, thereby facilitating timely intervention and treatment and reduction in hospital visits. One of the mentees' presentation, I don't know for accuracy if it was group 1 or group 2, that mentioned it in terms of liability when it comes to AI tools. In the subsequent slides, we'll be able to see, the literature on that. The next slide, which is a continuation of the definition of key concepts, is about health technology law. We had already, we have already mentioned what health technology is. So the law is just a legal framework governing the development, regulation, and use of health technologies, which includes the regulation of medical devices. We made mention of NAFDAC regulating drugs and medical devices in Nigeria, but in the subsequent slides, you will see the institutions that regulate it here in the United Kingdom. Then you have other healthcare services as well as the use of data in health and care settings. They will have medical ethics. Mr. Egwatu has, as a fact, made very good illustrations and demonstrated what medical ethics is. And here you see that the moral principles by which medical doctors must conduct themselves. And one important thing we should note is that medical ethics is not static, it changes over time. And with the advent of medical technology, with the advent of health technology, there has been changes around it. So that's why, just like Mr. Guatu said, that for beneficence, which is one of the 4 pillars of medical ethics, doing good, acting in the best interest of patients. As a doctor, you should always do good for your patient. Anything that he's doing, contrary to that, you're not working in line with the ethics of the profession. And Mr. Guatu also rightly pointed out that these ethics, as much as they are moral principles that guide the way medical doctors behave, they are now coded. They are now coded in laws, of countries. That's why you have in Nigeria. He made mention of Section 42 of the 1999 Constitution of the Federal Republic of Nigeria as amended, which talks about justice, which is a very good one. So they are not just medical ethics or moral principles, but they are now laws that need to be complied with, rights that patients enjoy. You have non-malfeasance, to do no harm. As a medical doctor, you are due to ensure that you do not do anything, you don't engage in any practice, that will harm the patient or have the potentiality of harming a patient. Then you have autonomy. These are issues that have been discussed. Like the patient is the king, and you must respect the patient. So, in terms of medical treatment or any form of medical intervention, you ordinarily need to seek the patient's consent before you do that. And one thing I must add is that it's not just to seek a consent and obtain it. You must ensure that that consent is a function of sufficient information having been given to the patient to enable the patient make an informed consent. It doesn't matter how you perceive that consent that is given or the decision of the patient. What matters is that that is the patient's right, and he can use it however he chooses to use. That's why Mr. Guatu made mention of a Jehovah Witness who said, I'm not going to take blood transfusion because my religion does not permit it. So you need to oblige the patient. Then you have justice, which is equitable distribution of health resources. There is a somewhat divide between the underserved or the rural communities and the urban communities. But as medical practitioners, we should ensure there is an equitable distribution of these resources to ensure that people get what they deserve, irrespective of considerations. We'll have the next slide, which is ethical, which is on ethical issues around the application of health technology. On ethical issues around the application of health technology, you have transparency and accountability. Just hold on, let me see. Excuse me. Yes. The first, I jumped the slide. It's actually slide 5. The ethical issues around the application of health technology. As a precursor, patients should be aware of how new technologies affect their treatment and personal data. Mr. Guato had already mentioned this. So it is our duty as healthcare professionals to ensure that patients are aware of how treatment, how these new technologies will affect their treatment and personal data. And it's good to let them know the benefits and the risks so that they should be able to make an informed choice or informed decision. Then you have these ethical issues around data privacy and confidentiality. Are you with me?
Yes,
Hello?
sir, we are. Yes, sir,
Okay.
we're with you.
Yes. So these ethical issues around the application
Yes,
of
sir,
health.
we are with you.
Yes. Yeah, you have data privacy and confidentiality. That patients' health data must be kept private and made confidential. Mr. Guatu made mention of telemedicine, that he's impressed that the code of medical practice, which is as far back as 2008, yes, even made mention of telemedicine section 22 of it made mention of telemedicine that patients information should be kept private, which is a good one in the right direction, despite the fact that as we speak, there is no known law that regulates health technology in Nigeria. The digital health bill is still before the National Assembly, which has not been passed into law. So for data privacy and confidentiality, there is need to protect patients' records and ensure privacy in electronic health records and telehealth platforms. Then as healthcare professionals, we are under an obligation to protect this sensitive patient information from data breaches in cloud-based systems and connected devices. As we proceed, you will see suggested measures that can be devised to ensure that there will not be any infraction when it comes to, or any breach when it comes to patient data. They have equity and access. This equity and access centers on justice, which is ensuring that digital health tools do not widen the gap for marginalized or rural populations. So in order to cushion the effects of this, there is a literature that has suggested a digital first primary care. That is ensuring that these health services, which are modern, the technology, can actually get, to the desired people who need it, ensuring that they get to the underserved and the rural communities. Then introducing a tailored-based healthcare solutions to cater for rural communities' specific challenges. Yes, for there to be an equitable distribution of health services, you must ensure that as healthcare practitioners, you engage these rural communities to know what their specific needs and challenges are, so that whatever you are doing for them should be tailored towards that. That's the only way we can achieve this, justice as one of the ethical principles that we need to oblige as healthcare practitioners. Then you have autonomy and informed consent. Obtaining informed consent ensures patients understand treatment options and risks thoroughly. I have already mentioned this earlier. So in order to achieve this, because these are health technologies which are complex in nature, so you need to be clear in your communication to be able to give the patients the benefits and the risks involved, so that the patient will be in a position to make an informed choice or informed decision. Then you simplify explanations through analogies and visual aids for better understanding. There are patients who have cognitive disabilities. They're not able to understand very well what you're saying. So you must devise ways of, communicating better to them. It could be through visual ways or signages and all of that to, get a better understanding. Then you have educating patients by providing comprehensive information about the risk, benefits, alternatives to AI-driven treatments, ensuring that you understand it and implications of their choice. I had already mentioned this earlier. You can also use interactive consent platform through questions and answers. That will enable you, understand the patients well and know what their preferences are. The next slide is a very important slide in view of one of the posers or question that either the group 1 or 2 had asked about who is liable for any AI error. So you have transparency and accountability. AI-driven diagnostics or robotic surgeries are not error-proof, thereby raising concerns about determining liability for errors. So now, how do we determine liability for errors in AI-driven diagnostics or robotic surgeries? There is a literature that has shared the liabilities. One, Mr. Guato had mentioned it, but this is a further clarification on this as to where would the liability go to. Of course, there is the captain of the ship, theory, which is the physician responsibility. Despite AI assistance, there is someone that operates the machine. There is a diagnosing clinician. There is an operating surgeon. So if the person does not use it well, you work with, rules of engagement, and anything goes wrong, of course, it will come to the physician or the clinician that is responsible. So the liability goes to the person, even though it's an AI-assisted tool, but the liability goes to the physician. Then you have the manufacturer/developer liability. If an error is because of a software malfunction or faulty algorithm or a design defect, which potentially may be as a result of a bias in the algorithm. If there is a bias, it could pose a risk to the outcome. So once it happens, the liability will shift to the developer or manufacturer under the product liability laws. But what I don't know is whether in Nigeria there is a product liability law that can actually take, that can actually hold people liable, manufacturers liable for this. Because I know many of these technologies are imported technologies, but I know there should be a way around it. Then you have the hospital liability. Healthcare institutions can be held liable for failing to properly train staff using unapproved AI tools or providing inadequate supervision of robotic systems. Then you have the black box problem. This is where, it's not very clear as to who should take the liability. Is it the manufacturer or is it the clinician? So where this happens, there are two ways to work around it. the use of disclaimers. You can use the disclaimers to define the platform liabilities and limitations, or also ensuring that there is professional indemnity. You obtain professional indemnity insurance to cover any potential claims owing to health tech related negligence or errors. In this country, for a law firm of solicitors, which is like a limited liability partnership, they have a professional indemnity insurance of 3 million. Then for a solicitor, just a solicitor, every solicitor has a professional indemnity insurance of 2 million, which means that in cases of negligence, which has been taken against that solicitor for any kind of infraction that has to do with health technology related, you proceed against the insurance. So that's why in the developed world, these things seem to be working better than in the developing and the underdeveloped world. Then you have the human-machine relationship, collaboration between humans and machines to improve patient care and outcomes. In this human-machine relationship, because of the introduction of health technology, there is now a synergy. There is a connection, a chemistry between humans and machines, which is aimed at improving patient care and outcomes. But despite this, there is need to maintain the clinician-patient relationship, which is built on quality care support rather than over-reliance on automated systems. Let me break this down. Yes, with the introduction of these health technologies, let us not forget that there is nothing like the relationship between a patient and a clinician, because this relationship is built on empathy, compassion, and communication. AI does not communicate with anybody. These health technology tools do not communicate with anybody. Of course, they communicate, but the communication from them are more theoretical than, even if they are practical, you're not seeing the person, you are seeing an equipment, you are seeing an instrument, you are not seeing a human being. Then you have the digital divide, which is digital illiteracy hindering access to healthcare. Of course, if we have, like in Nigeria, if we have imported these health technology tools to Nigeria and we want to use them, that's technology transfer, and we're not able to train these healthcare practitioners on how to use them, that means the problem we are running away from, we still have it. There will still be that digital divide. So there is need for that for healthcare practitioners to be empowered through tailored training in health tech. The next slide. You have the dilemma of principles of medical ethics in the era of health technology. Dilemma of principles of medical ethics, simply put, means these are principles or values that are in conflict with the medical ethics that we are aware of, that now make healthcare delivery services more difficult to achieve. Then we also need to know that health principles, the core principles of medical ethics, that's to wit, beneficence, non-malfeasance, justice, and respect for autonomy, remain the foundational principles of medical practice. But then, with the advent of this healthcare technology, it has created new ethical challenges in applying principles fairly and effectively in healthcare. We have a paradigm shift from human-centric to human-mediated, data-driven decisions, thereby introducing the issues of accountability, data privacy, and equity. What do I mean by this? Because we now make use of AI, we make use of health technology tools and equipment, to render healthcare services. There is now, an emphasis on, artificial intelligence as against human intelligence. So this brings an issue of accountability. Who will you hold accountable? But we have already answered that in terms of accountability. Data privacy. How do we ensure that patients' health information or health data are private? And how do we ensure equitable distribution of resources? Then you have the AI algorithms, which are a complex device with hidden or not easily understood systems for professions to truly give informed consent. So with this, there is an issue about getting a patient's informed consent when it comes to health technology tools, autonomy. Then you have the technological coercion. Patients, there is a feeling among patients that they are being coerced, to, make use of these new technologies, even against their wishes. You have the human connection. I had already mentioned this about the empathy and the emotional support, which a clinician gives, which we don't get from AI and all these other health, technology tools. Then you have breaches of health data, which may result in the exposure of highly confidential, personal and genetic information because of cyber attacks, which runs fast of now malfeasance, which is do no harm. Hello? Can you hear me?
Yes, sir, we are with you.
Okay, yeah, with me. Okay. Then you have the next slide, which is on the key health technology regulators and standards with a case study of UK and Nigeria. You have the data protection and privacy regulations. For UK, you have the Information Commissioner's Office, which oversees data protection and privacy issues related to health technologies. This is achieved through the instrumentality of the General Data Protection Regulation, that's the GDPR 2018, and the Data Protection Act 2018. So healthcare, tools are governed under this Data Protection Acts. The regulation itself and the data protection, that's for you. The equivalent in Nigeria is the Nigerian Data Protection Act, which is the key legislation. You also have the Freedom of Information Act. Then you have the Medical Device Safety. For UK, you have the Medicines and Healthcare Products Regulatory Agency, which regulates medical devices, including digital health technologies, ensuring they meet safety standards, performance standards, and all of that. That's why for any of these medical devices to come to the UK, there should be a badge on them. That badge is a kind of licensing, meaning that they are safe to be used. Then all medical devices must also be registered with the MHRA before being placed on the UK market. For Nigeria, the Federal Minister of Health is responsible. In the presentation by one of the mentees group, they mentioned it, the oversight function they have. So the nurse monitoring analysis and good use of medical devices. You also have the NAFDAC, which I had earlier mentioned, section 5 of it. Then the next slide is professional regulators. For UK, you have the General Medical Council, Nursing and Midwifery Council, the Health and Care Professions Council, which sets standard for professions using these technologies. Then Nigeria, you have the Medical and Dental Council of Nigeria, setting standard and ensuring that it's only those who have the qualification that can practice who are being satisfied. Then you have the Medical and Dental Practitioners Act and the Code of Medical Ethics of Nigeria. About telemedicine, that's the one mistake Guatu mentioned, which reinforces patient professional confidentiality and mandates that any patient information a healthcare provider must be kept private. They have the role of the Nursing and Midwifery Council of Nigeria for nurses, Pharmacy Council of Nigeria for the practice of pharmacy, ensuring standards are met. For online pharmacy regulation, which is worth mentioning, that's the regulation of 2021. It regulates internet-based pharmaceutical services and ensures compliance with relevant laws. Then you have the guidance and standards in health and social care sector. For the UK, you have the National Institute for Health and Care Services, NICE, which provides guidance and sets standards for health and social care practices, including the evaluation of digital health technologies. The Care Quality Commission is one of those organizations that are in charge of it, regulating the use of health technologies in the healthcare setting in England. They have Nigeria's own of course, the Federal Ministry of Health, which formulates policies and state standards. Then the Digital in Health Initiative, of precursor to the Digital Health Services Bill, which is currently before the National Assembly, not yet passed into law. Please, are you still with me?
Yes, sir, we are with you, sir.
Okay, thank you. Then you have the cross-border legal considerations in health technology with a case study of UK and Nigeria. You have the patient data protection. Of course, different countries have different data protection laws that control the exchange of personal information. So ensuring compliance with international and local data protection requirements, such as the GDPR, the DP 2018 for the UK and the Nigerian Data Protection Act, is critical to protecting patient privacy and preserving confidence. The legal factors such as getting express patient consent, adopting strong data security measures, and establishing clear data sharing agreements are all essential components of a compliance cross-border data transfer. As we proceed, you will see why it is important that patient data is protected. And in order for us to achieve that, we will have to, have extra layers of protection in terms of, ensuring that there will not be any hacking or any data breach. Then we'll have the intellectual property rights with multiple stakeholders in health technologies, such as the developers, healthcare providers, patients, and regulators operating across different countries. It poses various challenges around data protection, jurisdictional and enforcement issues. Then you have regulatory harmonization challenges. Both Nigeria and the UK have different health technology regulations. However, effective harmonization of these regulations will facilitate smooth operations for both countries. Dispute resolution. With players from different countries, there is bound to be disputes. And for these disputes that arise, in health technology deployment, there is need for a contract review to determine the country that will entertain jurisdiction. Then you have to also adopt alternative dispute resolution to resolve disputes. You engage the services of a legal expert versed in legal systems of both jurisdictions. Then ensure enforceability of judgments once obtained by checking any reciprocal enforcement treaties. The next slide. You have the monitoring systems, which is continuous monitoring helps dictate and address compliance issues promptly. This continuous monitoring is just like one of the groups made mention of, regular audit and all of that. So these are ways of monitoring what is happening in these healthcare technology systems to ensure that they are up to date and there are nothing, happening around them that will potentially cause a breach. So that there needs to be continuous monitoring, which will help to dictate and address compliance issues. They have making liability management crucial for digital health platforms. Clear terms of service and disclaimers must define the platform's responsibilities and limitations. We had earlier mentioned this in terms of who do you hold to account for anything that goes wrong. So, for example, a telemedicine platform should clarify that it provides consultations, but does not replace in-person medical care when necessary. So that is why, in as much as it's good to embrace these health technologies, but that should not displace the in-person medical care. That inputs that a human being should do to ensure that these systems are safe. They have obtaining professional indemnity insurance. I had earlier mentioned this, that digital platforms should obtain professional indemnity insurance to cover potential legal claims arising from errors, omissions, or adverse outcomes. Strengthening data security and privacy. Yes, I said I was coming to this. In order to ensure that our health data are safe and remain private, which they should be, we need to adopt a zero trust architecture to treat all network activity as a threat, except verified and and implement the use of multi-factor authentication, which is MFA. A multi-factor authentication is an extra layer of protection, which ensures that it's only those who should have access to our health records or our health data that should have access to them. Then you have proactive risk management. We need to conduct formal compliance audits, vulnerability scans every 6 months, and annual penetration testing to mitigate risk. All these measures are measures to ensure that the systems are safe. Then you're holding healthcare practitioners to account. This is very, very good. Effective prosecution of healthcare-related infractions by different professional regulatory bodies and the courts through handing them proportionate sanctions. The next slide. Use of international treaties. You have treaties like Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, to enforce health technology IP rights across borders. And for this particular agreement, Nigeria and the UK are signatories to the World Trade Organization, and the World Trade Organization coordinates the TRIPS agreement. So in terms of health technology transfer, between Nigeria and UK, there won't be any problem because these TRIPS should be able to handle issues around intellectual property. Then you have the clinical safety standards. Healthcare technology providers are mandated to conduct clinical safety cases that demonstrate how safety has been integrated into the development and deployment of their products through rigorous testing of both software and hardware to ensure reliability and effectiveness. This will give confidence to patients that their data is safe or their data are safe, and also make sure that the systems are safe generally. You have effective feedback mechanisms aimed at improving performance and potentially maintaining compliance. For whatever we do, there needs to be feedback. Feedback is what enables us to know where we are, what we are not doing well, and how we can actually improve. Then you have the whistleblower policy and protection. Yes, the system should create secure, anonymous reporting channels for potential violations. Where it says anonymous, I know it's not everybody that wants to blow a whistle and wants to be known, because people are afraid of what happens to them afterwards. But there should be systems that should make it anonymous so that even when you make these reports, nobody should know about your identity. They have comprehensive staff training. Of course, we know that training staff and retraining staff and continuous education will ensure that these people who are managing these health technologies are up to date in their skill, practice, and regulations to ensure that whatever they are doing are up to standards. Then you have the conclusion. In the conclusion, we have digital health tools as a complement. Yes, we have health technology, which has come to improve, healthcare delivery services, but it should not in any way displace human healthcare inputs. That's one thing we should understand, but it should complement it. Then we have holding healthcare practitioners and institutions to account. There should be disciplinary action, criminal prosecution for gross negligence, civil action for negligence and breach of patient's confidentiality. Then staying informed and being proactive. There needs to be continuous learning and proactive measures, which ensures responsible innovation and patient protection. We need to have a balanced approach. Successful navigation of health law technology requires integrating ethics, proactive regulations, legal knowledge, and implementing robust compliance measures. Then we have protecting patient rights. Diligent compliance with law safeguards patient rights in evolving health technology landscapes. As healthcare professionals, we act as safeguarding professionals to ensure that the health data of patients are safe, they are private, they are kept private, and they are kept against any form of breach. Then there needs to be improved technology infrastructure in remote areas. That was why in the preceding slide, there's a place I talked about the digital primary care. That's taking these healthcare technologies to the underserved or the rural areas to ensure that there is equitable distribution of resources in line with the 4 pillars of medical ethics. Thank you so much. You have the references. Yeah.
All right. Thank you so much, Mr. Emmanuel, for your very wonderful presentation. It was very, very analytical, and it showed us some of the comparisons between medical health tech laws in the UK and Nigeria, drew comparisons, and we're able to see some of the ethics and how they interrelate with each other. So thank you so much, sir, for your very wonderful presentation. From the side of the mentees, we'll be taking questions right about now. So after listening to Mr. Ebenezer and Mr. Emmanuel share their presentations and their thoughts, also in line with the research you guys have made, are there questions people would like to ask our mentors in relation to the topic for today? And if they are, you can do that by the raise of hand. You can send your questions into the chat box and then we'll take them. Does anyone have questions? Do we have questions? Please, I encourage all of us I encourage us to ask questions. These are means that we use to get more out of the mentors, to just also get them to share more in line with the conversation, and seeing that medical health tech and law is a practice that is very, very what's the word I'm looking for? It's a practice that we see all around us. It has to do with our health. It has to do with how the laws comply with the medical practice. And like they said, health is wealth, right? So anything that has to do with our wealth, we should stay abreast with the information things to it. So please, if you have questions to just overall improve our understanding of what we have had, you can do so. You can ask, we can take a question or two, right? So please, if you have a question, it's time for you to do that right now. Okay, so I assume we don't have any questions in today's class. All right, in the absence of any questions, I want to say a big thank you to Mr. Emmanuel and Mr. Ebenezer for for the delivery of today's topic, and helping to dissect the subject matter of today, and also giving feedback to our mentees presentation. For the mentees presentations are a core aspect of our class. So please, we always entreat you to remain prepared throughout the course of the program, as you'll be required to make presentations week in, week out. Right, so please let's do well to pay attention to tasks that will be given, and let's work together as a team to ensure that we are refining ourselves and we are getting better in the light of the field of medical health tech and law. So just before we go, I want us to quickly take pictures. So if you can, please turn on your videos. Let's take a quick screenshot and then we'll call it a day. Thank you so much, Mr. Emmanuel. And please turn on your videos. Let's take a quick picture and then we'll call it a night. I'll give us 1 minute to do that, to turn on our videos so that we take a 1-second picture. Okay. All right. So please, we can all smile for the camera. We'll be taking our pictures now. All right. Thank you very much, everyone. We have done that. Yes. Thank you.
Dennis,
And with
before
that,
we
we have
go,
come to the end of today's session.
yes, before we go, let
Yes,
me
sir. Please go ahead,
just
sir.
add quickly. Can you hear me? Let me just add quickly. Firstly, thank you,
Yes, sir, we can
Mr.
hear you, sir.
Emmanuel, for that detailed and robust presentation. Professional indemnity in Nigeria is a huge challenge. Our insurance industries have not been able to live up to that challenge, so it is still a big gap. Here, medical negligence damages rest squarely on either the hospital or the medical doctor that is cited for medical negligence. So it is still a developing area, and it's also calls for advocacy from all of us here, because all of you here have joined. You have joined. You're not just here to take the lectures, get your certificate, and go home. It is that identified gaps, steps should be taken to fill in those gaps. That way, we make our health system and healthcare service delivery more robust, more integrated, and most importantly, safer for the patients. Thank you all, and have a pleasant night rest. Sorry, I couldn't turn on my video. So I said earlier, I'm not feeling too strong. In fact, my coming here this evening is a miracle. That's all I can say. I just got myself to talk like this from around 2 a.m. Yeah, around 2 p.m. this afternoon. Since Friday, I've been down and I've been on medication. But maybe because of this class, God granted me speedy recovery, and I'm able to make my presentations. Thank you very much. See you guys next week. And please turn in your materials on time. Dennis, let them know the deadline on when to turn in their materials. Thank you.
All right. Thank you very much, sir. So sorry about your health, sir.
Dennis,
Yes, sir. I can hear you, sir.
I don't know if you just give me a few seconds for audience. Mr. Ebuato, thank you so much for all that you do for this mentorship organization. And I'm happy to have connected with you. And I'm seeing your CV is very rich. So I believe that you will rub off for me, and we'll continue to
And vice
meet.
versa, sir. And vice versa.
Okay,
what's going to happen? We are going
yes.
to exchange contacts. Dennis, kindly forward my contacts to him. Yes, so we can chat more on WhatsApp. We can
Thank you. I
compare
appreciate
notes
it.
and do
I
things
also
together.
appreciate all the participants, the two groups, Group 1 and Group 2. You all did a very wonderful presentation. So continue in that direction. Just like Mr. Eguato rightly pointed out, we are all stakeholders in health law practice in Nigeria. So we must all join our hands to improve the laws in Nigeria and ensure that it meets up with the standards in line with the other developed countries. Thank you so much, all.
All right. Thank you very much, sirs. Thank you to the mentees. Do all have a lovely evening, Mr. Ebenezer. We wish you speedy recovery. We pray that God grants you the strength to keep staying strong and committed to the cause of medical health law. Thank you so much, sir. Good night, everyone.
Thank you.